firstly, I'd just like to acknowledge the Attorney General of Samoa, Sue Helene Warwick, and the Assistant Police Commissioner, Ifo Morale. Sorry, I don't have my glasses on, so I can't read what I've written. But for their opening comments this morning. And I'd also like to just thank PILON for and just express my thanks and gratitude for the invitation to come and present to you today. So I am very grateful for the privilege to be able to speak to you all about the role of witness support officers and the role that we play in Australia. But I would also like to acknowledge the witness support officers in the room and those who you've all just heard of, and just the incredible work that you are all doing. So I work for the Victim and Witness Assistance Service, which is part of the Public Prosecution in Victoria, Australia. So I just thought I would start by just providing a brief historical and legislative context of how our service was established. So prior to 1994, really, the idea that victims of crime should be afforded any special consideration or treatment was really not existed. They really were just considered another witness in the prosecution, or if they were families of deceased, just another spectator in the prosecution, because we are a statutory authority and we prosecute offences on behalf of the community of the state of Victoria. And therefore, we don't act on instructions in the same for a victim in the same way that an accused person can engage a lawyer. So that first kind of emerging kind of recognition, if you like, that victims ought to be given appropriate consideration really happened in 1994 with the Public Prosecutions Act, which said that the Director of Public Prosecutions does have an obligation really to ensure that the prosecutorial system does give appropriate consideration to the concerns of victims of crime. It took a little while longer, so 11 years, and then we had our most significant piece of legislation and legislative reform in relation to victims of crime, and that was the Victims Charter Act in 2006. And that piece of legislation really sets out a number of key obligations that prosecuting agencies and victim support agencies in Victoria do have. So, namely, the most important ones are victims, of course, have the right to be treated with the respect, dignity and courtesy that they deserve by the prosecuting agencies and victim support agencies. Victims have the right to receive information relating to their rights and entitlements. So that would include, for example, a victim survivor in a family violence or sexual assault. They have a legislative entitlement to give their evidence in a remote witness facility should they choose to. It also includes their right to, they can have a screen if they like. They have the right to know the charges, what the alleged perpetrator has been charged with. Once upon a time, once again, prosecutors were reluctant to provide that information out of concern that it might jeopardise the prosecution in some way, and it might be considered to be coaching them or influencing what a witness might say in court. We also are obliged to provide information about their rights and entitlements to compensation. And once again, historically, there was a reluctance to provide that information out of concern that a defence barrister might put or suggest to a victim that they've only complained about an offence in order to receive some kind of monetary compensation. Victims also have the right to be consulted on significant decisions. So in Victoria, we must consult with the victim of crime when there may be a discontinuance that's been considered. So when there's consideration given to withdrawing all charges, or if there is consideration to substantially modifying charges. And yeah, so that also relates to plea decisions. So we must consult with victims, but of course it's not the deciding factor, but due consideration does need to be given to what a victim's views are in relation to those significant decisions. So our service was established in 1995. When our service started, there was one social worker. About a year later, it doubled to 2. When I started 15 years ago, I was one of 4. So, but now I'm proud to say we have 26 social work practitioners that work in the service at the OPP. The care role is to provide that critical support and assistance to victims and witnesses and families of deceased in indictable matters. We sit within the Office of Public Prosecutions and we support throughout the court process from start to finish. So typically the life of a prosecution might be around 6 months to 2 years. But having said that, if you have several appeals or retrials, I know I personally have supported a young woman for 9 years. So that matter was allocated to me in 2010 when I was a social work practitioner, and I did not say goodbye to her until 2009. So for some people, unfortunately, the wheels of justice can turn incredibly slowly. We are a non-evidentiary service, and that's really important. And I know some of you touched on before that as witness support officers, we don't have a counselling role. There is a very important reason for that. So the support we provide is very much process driven. If we were to undertake a counselling role, then we would have our victims talking about the offending. So if they're talking about the offending, they're talking about their evidence. And then if they're talking about their evidence, we need to be very, very careful that we are not seen to be coaching a victim in any way who is also a witness, and therefore influencing what they have to say. And we will often have defence barristers who will ask in cross-examination, have you spoken to the witness support officer? What did they say to you? What was discussed? Even with prosecutors in proofing and conferencing, they'll ask, oh, so you met with the Office of Public Prosecutions. What did they say? So we really do have to be careful. So any kind of therapeutic interventions that we provide to victims of crime are very much limited to that crisis intervention, that debriefing, that critical incident kind of debriefing, particularly around unfavourable outcomes. So we work as a team, so we have a multi-disciplinary approach. So that includes the solicitor with conduct of the file, the prosecutor, the social worker and the informant. So it is really important that we're all on the same page. We provide that consistent messaging to victims of crime, and we all play our own unique role in how we support and provide that support to victims of crime. The aims of our service are to ensure that victims of serious criminal offences in Victoria receive the best possible care, support and information throughout the prosecution process. So it really is around being available to give that information about the process to victims and respond to any questions or concerns that they may have along the way. As an integral part of the prosecution team, we ensure that the needs and concerns of victims and witnesses are identified and taken into account throughout the prosecution process. So it is important that we provide that advocacy for victims of crime and do make sure that that the needs and concerns of them stay on people's radar. Yeah. So we enhance prosecution process by supporting victims and witnesses to enable for them to give their evidence to the best of their ability. And this is really important. So we actually don't need to coach victims of crime. We don't need to say, look, they're probably going to ask you about this. They'll ask you these questions and this is how you should answer that. We don't need to do that. When victims are informed of the process, when they know what to expect, when we walk them through an empty courtroom beforehand, show them where they're going to stand, where they can expect to see the judge, where they can expect to see the accused person. When they know all of that and they don't need to worry and fill those gaps in their mind, when they understand exactly what their role as a witness is, you can bet your bottom dollar that they will give a higher standard of evidence because they can just focus on their role as a witness and they don't need to worry about those other things because they've been able to have a conversation and we've been able to answer those questions and demystify the process for them. And we work collaboratively with agencies to improve the criminal justice process so as to minimise the trauma and stress experienced by victims of crime and to help them to heal and recover. Our role as witness support officers is very specific. So we are there because we're not counsellors. So we are there to just support them throughout the court process. We will undertake an assessment and then we will refer them to other services. But it's also really important that those other community agencies have a sound understanding of the criminal justice system as well, so that they can also provide that support and also that consistent messaging. I think that is just so important for victims in this space. So, in a nutshell, what we do at the Victim and Witness Assistance Service, we convene legal conferences. Conference is just a fancy name for a meeting, people. We organise meetings and we organise meetings with the legal team. So we provide those opportunities for victims to meet with the prosecutor, to meet with the social worker and the police informant. We come together and we will explain before each process, so each major process, what they can expect, what is going to happen at court. We demystify the court process and we translate legal terminology. We do this all the time, every day. We know the jargon. Victims of crime don't. Quite often it's their first encounter with the criminal justice system. We provide information and updates to victims and witnesses regarding hearings. We have those big hearings where victims might be called to give evidence, or there might be a plea hearing or a sentence. But in between, there's lots of little administrative hearings that happen. And victims might hear about, oh, there's this criminal mention, but they don't know what it means and they don't know what has happened, and they often just get forgotten. So we just make sure that we provide that update so that they're kept in the loop and they understand what is happening along the way, even if they haven't been present. We will do those court and remote witness tours so that they know what to expect when they're going into court. Also, so they can have, really as a trauma-informed practice, they can have some agency and choice over where they may choose to give their evidence. So, for example, whilst a victim survivor of a sexual offence is entitled to give their evidence in a remote witness facility, they might say, well, Susanna, I feel like I really would like to give evidence in court, but I'm just not sure. I can't imagine what it would be like. So we will show them what the courtroom looks like. We'll show them a remote witness room, and then they can make a more informed decision about where they think that they would like to give their evidence. We do provide that court support, particularly for the most vulnerable victims and witnesses. So we will sit with them in court, but it is very much just a passive, we call ourselves passive support people. So even in the remote witness room, we do not engage and we do not speak to witnesses whilst they're giving their evidence, because again, we can't seem to be coaching them in any way. lots of liaising with solicitors and prosecutors and police informants, that crisis counselling and debriefing that I spoke about earlier. We provide secondary consultations to police, solicitors and other agencies in relation to victim engagement and victim management, and we provide that advice. And we ensure that the needs and views of victims of crime are heard and appropriately considered, and we do facilitate those referrals to other agencies. So that's what we do on a practice level. There is also a strategic function within our service that I'm largely involved in, and that is around delivering training to solicitors and prosecutors. So we certainly do not expect solicitors and prosecutors to take on the role of a social work practitioner, but it does make a difference to provide that education around trauma-informed practice and care and engagement with victims, so that they can engage victims in a more meaningful and helpful way. We deliver training to outside organisations. Again, as I touched on earlier, it's really around making sure that those other agencies that provide services to victims of crime also understand the inherent complexities of our system and the system that their clients are engaging in, so that they can provide a better standard of care and support to those people as well. And we contribute our expertise to policy change and law reform on matters relating to victims of crime. So I sit on a number of committees that look at policy change and law reform as well. Why we do what we do. So we support victims through the court process because their levels of emotion are often very high. The court process is often very stressful and re-traumatising. Victims are incredibly triggered. The court process, as you heard, just can be incredibly long for some victims, particularly when there's multiple adjournments, and COVID certainly has not helped. So we had a backlog before COVID, and then that just got, bigger and bigger as the last couple of years have gone on. So court hearings are often delayed. Many people fear not being believed. This is an adversarial system, and it can be very triggering for someone to be told under cross-examination, I suggest to you that you made it all up, that you're lying. And it can trigger that little girl who, it might be a historical case, who spoke to an adult when they were being offended against many years ago, and then were just told, no, I don't believe you. So it is a very, very difficult system for victims of sexual and gender-based offences to be involved in. Many people have not been involved in the criminal justice system before. Often what they imagine it will be like might have been what they've seen on TV, and that's often American TV shows. And it's really nothing, and it's certainly not going to be wrapped up within an hour. So, it is really important that victims are given that support, that information. Many people are reluctant to participate in the court process for a number of reasons. And it's not always a just system. I often say there can be a really big difference to justice and fairness. So what might be considered justice isn't necessarily fair for a victim, and someone who's been adversely impacted by crime. And it is largely an offender-orientated system. That is the reality that we face. This is my last slide. I tend to talk really fast when I'm nervous. I don't know through this, but so I just thought I'd mention some key considerations, particularly when working with victim survivors of gender-based crimes. So a positive victim experience is not necessarily outcome dependent. So whilst victims engage with the system, and of course they want that outcome at the end, and would like that guilty verdict, there are a lot of other takeaways that a victim can have, that they can walk away thinking it was actually worth it, even if I didn't get that guilty. It's largely centred around how we treat them, so their experience. So several years ago, I think it was about 5 or 6 years ago now, I can't provide the document, but the Office of Public Prosecutions commissioned a study by the Centre for Innovative Justice, and it was around how we communicate, so victims' experiences in relation to how we communicate with victims when we are having difficult conversations, essentially, largely around significant decisions like plea resolutions and discontinuances. And a lot of those victims who were interviewed said it wasn't necessarily the outcome, but it was how they were treated. So being treated with respect, being listened to, and just feeling heard. So, and some of the commentary was around some victims saying, well, you know, my matter was resolved, or charges that were significantly less, or even it was just resolved, and the way the prosecutor sold it to me was like, well, you should be happy because it means that you don't have to come to court and give evidence, and that would be terribly stressful for you. But we can never assume what a victim wants to get out of that process. And for some victims, they said, but I really wanted to be heard. I really wanted my day in court. So it's really important to remember that how we treat victims will significantly impact on their experience going through this system, despite what the outcome might be at the end. It's important for victims to feel believed, and it's absolutely okay as prosecutors to say, I do believe you, we are here because we believe you. It is also really important at the same time, we need to manage expectations for victims, particularly often in gender-based crimes. They are difficult to prove. There's often no other witnesses. It is a word-on-word case. So, but even if we haven't been able to prove it, it doesn't mean that there's no truth. So it's really around saying to victim survivors, it is important that you hang on to your truth. And there is that difference between truth and proof. And in our system, you know, that the standard is beyond a reasonable doubt to prove something. We've had juries come back delivering a verdict with tears rolling down their cheeks because they felt incredibly uncomfortable, but they knew their role as a jury. It had to be beyond a reasonable doubt, and they felt that the evidence just didn't quite reach their threshold. So even if a jury of 12 people think, you know what, that person probably did it, it's likely they did it, that's not enough. So, but it is important for victims to understand that it doesn't necessarily, that outcome doesn't mean that they were believed. Early engagement, I think, is really critical, particularly when we're looking at reluctance. Okay, when we have reluctant victims, it's really important to engage early, build that trust, but understand what that reluctance, what is underpinning that reluctance, what are those barriers. Once you know what those barriers are, then you can have a go at addressing those barriers. Once upon a time in my office, we were often not allocated a matter or referred to support a victim until several days before the first hearing when someone was required to give evidence. And we really had very little opportunity to engage and, you know, ascertain what those barriers were. Now we are referred at the same time that a solicitor is referred the matter. So our systems are much better. We can engage a lot earlier and our outcomes are a lot better, particularly when we're looking at reluctant victims, but also understanding reluctance, particularly relating to family violence, in the context of safety, both physical and psychological safety for victims. So for victim survivors in family violence, for them sometimes it might be, I can't be seen by the offender to be supporting this prosecution because if they think that I'm actually driving this, that's going to make me really unsafe because he just might come and get me and hurt me again afterwards. So I think that is really important. I've already spoken about managing expectations. What I wanted to end with was just a letter from a victim. Now this is shared with you with her permission, and it's also been de-identified, so I have changed the names. But I'll just read it out. So, dear Susanna, firstly, thank you for supporting me and helping me to understand the complexities of the justice system. I always knew that gaining enough proof for a historic case would be more than challenging. I cannot put into words my appreciation for everything the OPP and Victorian Police have done to support me and carry this case all the way through to the county court. I'm sure everyone involved is disappointed by the verdict. From my perspective, what happened to me has been validated. Victoria Police and the OPP believed in me, and that means more to me than the verdict. I found strength through this process and feel that over the past 3 years, I've grown as a person. Regardless of the outcome, David has had to answer to the justice system. When I started this journey, all I really wanted was to stand up and say this was not okay, to try and prevent it happening to someone else by making David think next time more carefully about his actions and closure. I have gained this along with many other positive things. I never went into this thinking it would be easy, and nor I don't think jail was the only answer to gain what I set out to. My motivation has been fulfilled. I have gained closure of a chapter that was open for too long. I know he's guilty, he knows he's guilty, and the important people know he's guilty. That's enough for me. For you, everything you've done to support me, saying thank you seems a ridiculous understatement, but thank you. Thank you again for giving me strength and believing in me, warmest regards. So I think for me, that email really just captures, it was an absolute team effort and just how well it works when we all work together. We all provide that consistent messaging and we all have that role to play. Anyone have any? Yes, we are. Yeah, so we're all qualified social work practitioners. Yeah, I really do. I think we've come a really long way over the years, and I have been working at the Office of Public Prosecutions, but this is my 15th year this year. And I remember, you know, when I started, and look, 15 years wasn't that long ago, but when I started, you know, there were some prosecutors, older prosecutors that had a more traditional approach then that would even ask us to leave the room when they conferenced victims, so they wouldn't even let us meet with victims. We've had, and I think just even with members of the judiciary, their approach has been a lot different. We do have some other systems in place now. We've very recently started trialling what we call ground rules hearings for all victim survivors of sexual assault. But even prior to those ground rules hearings, we did have some members of the judiciary that would ask that really just, it was simple, but it was really important information for victims so that they could engage victims in a trauma-informed way. So we had some judges asking the prosecutor from the victim how they would like us, for example, to refer to the accused person. So should it be by name? Should it be by the accused? You know, they were just mindful that how they refer to the accused person might be triggering for that victim. So yeah, they're just some examples, but I think there has been, we have a long way to go, but I am still very, very proud of how far we've come in those 15 years as well. Yes, there are. And this is another thing. When I started, there were no male witness support officers, and my old manager said there will never be a male witness support officer because there was this view that they can't support victims, that like we had too many gender-based offences and that they couldn't deliver the same service that we do. But we have two on our team. It's still very much female heavy, but they just play an incredible role. You know, sometimes we have conversations with victim survivors about what their preference might be. But I think, you know, again, I'll use the example of family violence. I think there's something very powerful in a male practitioner saying, that's just really messed up. Men don't behave that way. That's not, you know, you didn't deserve to be treated that way. That's not okay. So I think men are just as much part of that solution and that narrative, and I think they have a really important role to play in this space as well. Thank you so much.